EECMS, your Virtual Employment Equity Compliance Management Service.
Good morning, everyone. My name is Pieter from EECMS, a company dealing in employment equity, ensuring that all our clients are in total and full EE compliance. Also, throughout companies in South Africa, we are reporting here today from our virtual studios in Pretoria. Please bear in mind, we have virtual studios throughout South Africa in all the provinces. There will be a recording placed onto YouTube. When you go onto YouTube, please just type in EECMS and all our videos will appear on there. Again, if you have any questions, please type into the chat box. And what we will do is after this presentation, we will revisit and we will answer your questions. This session is about information and training on the summary of the Employment Equity Act, number 55 of 1998, as well as the Amendment Act and the regulations. Also to introduce the Amendment Bill. Okay, so let's start with the summary of the Employment Equity Act. The purpose of the Act. It is to achieve equity in the workplace by promoting equal opportunity and fair treatment in the employment through the elimination of unfair discrimination. It is also to implement affirmative action measures to redress the disadvantages in employment of designated groups. Ladies and gents, when we are talking about equity in the workplace, what does that mean? Okay, equity in the workplace means when you look at your workforce profile, and workforce profile would include all the employees employed by your company that's on your payroll, from your top management down to your senior management, middle management, junior management, semi-skilled and unskilled employees. Okay, so if you employ 100 people in total, your workplace and the equity in your workplace would be from top management down to unskilled. Then achieve equity. Okay, so what the Department of Employment and Labour would like to see companies to do is to see that you have reasonable transformation and that employees from designated groups are also equitably represented throughout the occupational levels based on the EAP targets. EAP targets equals economically active population, and I will get to that later in this presentation. Definition of designated groups. Designated groups include all your African males and females, all your colored males and females, Indian males and females, as well as white females, and all disabled staff. Okay, when we are talking about designated groups, your white females are still included for employment equity legislation purposes. Remember, this act is different from the BEE legislation. This is employment equity, and within the employment equity ambience and legislation, white females are still included, as well as disabled staff. Just as a matter of interest, your target for disabled staff for employment equity purposes equals 2% of your headcount. In other words, back to our example, if you employ 100 people in total, please try your best to achieve 2 people being disabled. Designated groups exclude white males and foreign nationals. For the white males attending this presentation today, please remember the following. The purpose of the Act is not to fire or get rid of your white males. Okay, it's just to see that should a white male maybe retire 3 years from now, and white males are already overrepresented in whatsoever the occupational level is, the company needs to try their best to see where the highest underrepresented races and genders are, and see that they can possibly find a person to be promoted and or employed in that particular race and gender in that particular occupational level. Okay, so you need to comply. Designated employer means all companies employing 50 or more people can also volunteer to comply. Should your company employ less than 50 people, please go and verify the industry that you operate. If your annual turnover is above the threshold in your particular industry, then your company are also deemed designated employer. In other words, let me give you an example. Agriculture, you can see the total annual turnover threshold is 6 million rand per annum. Let's assume you operate a farm and you have 10 employees, but your turnover is more than 6 million rand per year, then you're also deemed designated employer and also need to comply with all the rules as per the legislation. Okay, you can also go through the list there. I believe you did receive this presentation as well. It will also be placed onto YouTube by next week, Wednesday. Mining and quarrying, annual turnover above 22.5 million, manufacturing 30 million, construction 15, retail and motor trade 45, wholesale 75, etc. The list goes on. Unfair discrimination, no person may unfairly discriminate against an employee in any policy or in practice. Discrimination can be based on any of the following: race, gender, pregnancy, color, sexual orientation, age, disability, religion, HIV status. Okay, the list goes on. Conscious belief, etc. Surely and hopefully by now, everyone attending here today would quite be aware of what's allowed and what's not allowed with regards to discrimination. Medical testing is permissible when legislation requires the testing or when it's justifiable for various reasons. Typically, that would be as per the health, safety, and environmental legislation. To give you an example, should you work and or operate in a mining industry and people need to work underground, they call it a red card. The red card is permissible. Lung capacity tests to see whether a female is maybe pregnant or not, etc., etc. All of that is permissible. HIV testing is prohibited unless determined to be justifiable by the Labour Court. Okay, so what happens here is a lot of people, majority in your medical, in other words, your nurses, your paramedics, people working in hospitals, ICU departments, etc., those employees could be forced to undergo regular HIV testing because it is justifiable by the Labour Court. Okay, then you have, how does it work? You have inspectors. Okay, inspectors go out, they do investigations at companies to see whether the company is in compliance with the Act. And how does it work? Okay, you have the newly appointed Minister, Tulas, he was appointed last year. Then you have the Director General, and the Director General has the authority to appoint hundreds of inspectors throughout South Africa and throughout the provinces. And what do? They go about and they do investigations. They usually request certain documents in hard copy, your EE plan, whether you have a committee, whether you meet quarterly, meeting minutes, agendas, etc. And then they work through the documents, and if they are not satisfied, they can do one of three things. Power of the labor inspectors. Either they can give a company an undertaking to comply, to say we are allowing you 2 weeks to get your house in order, okay, or they can say there's a compliance order, we're allowing you 60 days to get your house in order. Okay, but please bear in mind, should a company, the third thing that an inspector can do is, should a company not have an EAP analysis, or the company did not have an EE plan, or the company did not submit the EA2 and 4 reports to the Department of Employment and Labour, that could result in an immediate referral to the Labour Court. I'll get to those three things. Please make a note of the following. You must have an EAP analysis, an EE plan, and you would have needed to submit it in the past should you have been a designated employer. For those three things, an inspector does not need to give you an undertaking or compliance order. The inspector can refer your company to the Labour Court immediately. Review by the Director General. On this slide, bottom line is the DG has the authority to appoint hundreds of inspectors. Those inspectors go out, they do investigations, they look at your EE plan, they look at certain documents, they request copies of those documents. They can even have interviews with your committee members, asking, do you meet at least quarterly per year? What is being discussed? Were you involved in the preparation and implementation of the EE plan, etc., etc.? Then you need to ensure that your company is in compliance with section 16, 17, 19, 20, etc. I will get to what those sections mean just now. Penalties for non-compliance with section 19, 16, 17, 22, 24, etc. And I'll get to what exactly those sections stipulate. No previous contravention of the Act could result in a 1.5 million rand penalty. Then section 20, 21, 23, etc. It could be another 1.5 million rand or 2% of turnover of your company, whichever is the highest of. In other words, for total non-compliance, minimum penalty could result in 3 million rand. Okay, 2 years ago, 21 companies did receive these steep penalties. The minister actually found that numerous companies actually budget for these penalties. So let's assume we have 3 million rand in the bank. We write a check, Bob's your uncle. Thank you very much, department. You have your 3 million. Now, Libas line, no, the Department of Employment and Labour will be back the following year. One previous contravention in respect of that provision, it's another 1.8 plus 1.8 million or 4% of turnover. In other words, thank you very much. We did receive your 3 million. The following year, it's another 3.6 million. So let's transfer the 3.6 million. Bob's your uncle? No, it's not. Previous contravention within 12 months, it's a good result in another 2.1 million plus 2.1 million. Following year, come back, another 2.4 plus 2.4. Okay, and it goes on to 2.7 plus 2.7 or 10% of turnover. Let's talk about those sections. What do they mean? Section 13 of the Act stipulates designated employers. Okay, you will need to implement affirmative action measures for designated groups to achieve equity in your workplace. Designated employers, you have to consult with your employees as per Section 16. I'll get to that. When you conduct an EAP analysis, I will get to that. And when you prepare your EE plan, and I'll get to that as well. Section 15 of the Act, designated employers, you will need to implement affirmative action measures intended to ensure that suitably qualified employees from designated groups have equal opportunity and are equitably represented on, ladies and gentlemen, all occupational levels of your workforce. What does this mean? As per Section 15, gone are the days where a company can say, but you know what, the majority of our employees are being non-designated on management levels and designated employees are on semi-skilled and unskilled levels. Okay. The Department of Employment and Labour and the legislation wants companies to try their best to see that there's equal opportunity and that your designated groups are also equitably represented. How do you determine that? You look at the EAP targets, you compare it to your actual race and gender in each occupational level. You then determine whether that particular race and gender is underrepresented or overrepresented. Should it be underrepresented, then you need to prioritize to see that should a position become available, where is your highest priorities before you promote and or employ. And I will get into more detail when we discuss the EAP analysis. Section 16 and 17 of the Act. Your company will need to take reasonable steps to consult with representatives of employees representing the interests of the workforce. When, of course, you do your EAP analysis, an analysis of your HR policies, when you prepare your plan, and when you complete your EI2 report. Please make notes of the following. When you constitute your employment equity committee, please ensure you have to have representation on all occupational levels. In other words, at least one person on senior management representing senior managers in your company. You will need to have one person on middle management representing middle managers within your company. You will need to have at least one person on junior management representing junior managers, one person on semi-skilled representing semi-skilled employees, and at least one person on unskilled representing the unskilled employees. Colleagues, of course, if you do not employ any middle managers, you will have zero middle manager person representing middle management in your company because by default, you do not have any middle managers. But let us assume it's a company employing 100 people with quite a big structure, then you will have at least one person on senior, one on middle, one on junior manager, one on semi-skilled and one on unskilled. Please note the following. Once you have covered your occupational level representation, you must then have an additional, colleagues, an additional African male representing the African males. Remember, it's not allowed to be the same person already representing the occupational levels. You are not allowed to double count. So you have one person in senior, one in middle, one in junior, one in semi, and one in unskilled. That gives you 5 people in your committee. Then you must have an additional African male, which is then person number 6, representing African males. Then an additional colored male representing colored males. An additional Indian male representing Indian males. An additional white male representing white males. Then an additional African female representing African females. Colored female representing colored females. Indian female representing Indian females and white female representing white females. Again, not to be the same person already representing the occupational levels. So now you say, but Pieter and EECMS, you are talking about a committee of 13 to 14 people. Yes, that is very, very likely. Then, should your company employ disabled people, you must have at least one disabled person representing the disabled. And then, of course, should you be majority unionized, preferably also have a shop steward and or union representative in your committee. Ladies and gents, I've been through personally 62 DG reviews the past year and a half. What we have seen is if your EE committee, they, meaning now the inspectors in the Department of Employment and Labour, they refer to it as the constituency of your committee. And if the constituency of your committee is not as prescribed as per what I have mentioned to you just now, the department inspector will tell you it is almost as if you have done nothing. Then the department will say, resuscitate your committee so that it is correct constituency and do everything over pertaining to your EAP analysis, pertaining to your EE plan, as well as pertaining to what you're going to submit to the department towards the end of 2020. Please bear in mind, if you do not have a committee, as for section 16 and 17, that could result in a 1.5 million rand penalty. Section 18, disclosure of information. Section 18 of the Act, employer, you have to disclose relevant information to the CEO, the EE manager, the committee, and employees when you engage in consultation for effectiveness or to ensure effectiveness. Okay, so please bear in mind the information pertaining to employment equity in your committee meetings need to be disclosed. Any and everything except your EA4, which details remuneration. I will get to that as well. The EA4, you do not salaries / remuneration / EA4 not to be discussed or disclosed in your EE committee meetings. Section 19. Designated employers, you will have to conduct an analysis of your policies, your practices, your procedures, your working environment. Then you will need to identify barriers that adversely affect members from designated groups. The analysis must also include the development of workforce profile to determine the extent of under and overrepresented races and genders in your workplace. In other words, when we talk about the EAP analysis, it is divided into two sections, okay? The one being qualitative and the other being quantitative. Qualitative analysis is the so-called barriers. Okay, there's 23 possible barriers. When you go through those barriers, you need to identify whether it is a barrier in your company, and if so, you will need to come up with an affirmative action measure on how to address that barrier. So let me give you an example. Something that I've seen last week again in a DG review. Let's say EECMS, we would like to employ a financial manager. In our company, we say it's a middle management position. And we advertise because the element, one of those 23 elements equals advertising of positions. And we say we're going to advertise for a financial manager in the Rapport newspaper. That would be deemed and classified a barrier. Why? Because if we advertise in the Rapport newspaper, it's a paper dominantly read by Afrikaans people and especially Afrikaans males. So you will take away the opportunity of the majority of people being from designated groups when you advertise for that position. So if we say this is our advertising strategy, back to the drawing board, we say that, okay, this is a barrier, and the affirmative action measure would be something in the line of going forward and in future, what we will do, we will advertise through PNet or OLX, or maybe on our website, career opportunities, etc. Because then you are targeting a pool of people, including African, Indian, colored, white, males, and females. Quantitative analysis, and later in this presentation, I'm going to show you practical examples. Quantitative analysis is where you will need to go to your EAP targets. EAP equals economically active population. What does that mean? Okay, the Stats South Africa took the more or less 35 million people between the ages of 15 and 64 and said out of this pool, it's more or less 35 million people. What is the percentage of African males? And the latest statistic on that is 42.8%. So then the department and the legislation wants to see that your company try your best to see that from top management to senior management, middle management, junior management, semi-skilled and unskilled, you try your best to employ 42.8% African males. If you, as an example, on senior management have 0 African males, that would result in a percentage of 0, resulting in an underachieved of 42.8%, resulting in your highest priorities. So the department would say, should you have employed a middle manager, and it was not an African male, since African male in my practical example is the highest underachieved race and gender in that particular occupational level, why did you not consider priority 1 and or priority 2, 3, 4, etc.? Okay. The EAP analysis, what I've seen in DG reviews, colleagues, it's the one thing that the department inspectors hammer companies on. This is the biggest document or the most important document that any company can have in place pertaining to employment equity. Okay, so what you have done, I'll get to a practical example as well. If you do not have an analysis, possible penalty of 1.5 million or 2% of turnover, the highest of, please bear in mind, this is one of the sections that the department inspector can refer to the labor court without a compliance order or written undertaking. Why do you need to do your analysis? You need to determine your highest priorities. And then, out of that, you need to start to prepare your EE plan. Okay, so the question from an inspector could be, but listen, XYZ company, if you have not done your EAP analysis to determine the highest underrepresented race and genders to prioritize, how could you have come up with an EE plan if you were not even aware where you were supposed to work on pertaining to the equality in your workforce? Then they also love the wording of our EE plan was informed by our EAP analysis. In other words, we had our committee, management and committee had a meeting, we looked at our EAP, and we used that EAP analysis to inform what we have done in our EE plan. As per section 20, you must have an EE plan on how reasonable progress towards equity in your workplace will be achieved. Please bear in mind, I've visited the past 11, 12 years, I've visited hundreds of companies that told me, but we have a plan in place. So then you ask, but give me your plan. I need to see whether it's in compliance with the legislation. Then they give the EA2 report. And they say, but there's my goals that I've submitted. No, ladies and gents, the EE plan, it's a separate document. The figures are being submitted in your EA2 as for your targets and goals. But the EE plan is a complete separate document that needs to be in your file, and it must be in the format of the EEA13. If you do not have an EE plan, it could result in immediate referral to the Labour Court. Section 21 of the Act, every year between the 1st of October online and the 15th of January, let's say next year, 2021, you will need to submit the EA2 and EA4 reports to the Department of Employment and Labour. Okay, those are reports indicating your workforce profile, the number of recruits in a 12-month time frame, number of terminations, promotions, etc., etc. I'm sure that majority of attendees in this meeting quite aware of what those reports entail. If you have not submitted your report, it could result in an immediate referral to the Labour Court for 1.5 million rand or more penalty. Please bear in mind your EA2 report must be discussed with your committee before you submit your report. Okay, I've seen on numerous occasions where you ask the committee, guys, how were you involved when you drafted this report? Did you agree? No, we never agreed, but top management or HR or our compliance division or whosoever submitted the report, but we don't even know what they have submitted. You have to discuss the EA2 with your committee prior to submission, not the EA4. The EA2 you will need to discuss. Section 22, if there's listed companies, JSE listed companies attending here today, as per Section 22, JSE listed companies or public entities must publish a summary of the report required by Section 21 in your annual financial report. Bottom line, pertaining to your workforce profile, you will need to show that in your annual financial report. If not, it will result in a possible penalty. Section 23, you have to, before the end of your current EE plan, start to prepare a new EE plan. Okay, so it's advisable, colleagues, 6 months prior to the expiry of your plan. So let's assume our plan at EECMS will expire the 31st of December 2020. Today it's the 10th of July. So it's advisable that our team get together and start to prepare a new plan. Because, colleagues, when your plan expires the 31st of December 2020, 1 January 2021, you must have a new EE plan in place. In other words, if your plan expired 30th of June this year, hopefully you would by now have a new plan that started 1 July. As per section 24, you must assign one or more senior managers to ensure the implementation and monitoring of your plan. Okay, bottom line, employment equity manager. Couple of rules of an EE manager. You can maybe write this down. It's not in the presentation. Number one, it must be a full-time employee of your company. Your EE manager must be a full-time employee. Number two, your EE manager must be part of senior management in your company. Basically, your EE manager will be the critical link between your committee and the CEO. Number three, the KPIs and KPIs, in other words, the key performance areas and indicators, must be included as part of the review of your EE manager, whether it's through an addendum of your contract or an additional letter just to state that at least annually your EE manager will be verified whether he or she has KPIs and KPIs and did in fact adhere to your monitoring of your EE plan. Okay, must be a full-time, must be a senior person, must have KPIs and KPIs, and number four, must report directly to the CEO. Those four rules are imperative. Please, if it's not in your EE manager appointment letter, revisit your letter and build those rules in. Section 25, duty to inform. Employer, you will have to display in your workplace where all the employees can see it, the summary of the Employment Equity Act and the basic conditions of the Employment Equity Act. Those are those big posters. You can buy them from the government printers. Please place it where all your employees can view it. In other words, maybe in your canteen or reception area, toilet facilities, wherever all the employees can view it. Income differentials, as mentioned, your EA4, you will need to submit your remuneration to the Department of Employment and Labour, and I did mention this is not a public document. Section 43 and 44. Should your company undergo a DG review or an inspection, please ensure that should the department have recommendations and they give you a due date of, let's say, the 26th of August 2020, colleagues, ensure that you provide the inspector with all the relevant information and recommendations as per his or her requirements on or before that date. Believe you me, if you have not done that and your deadline is the 26th of August, 27th of August, you will be referred to the Labour Court. And then we go and say, but you know what, we did mail it, maybe you didn't receive it, please can we talk about it? What can we do? The Department of Employment and Labour inspector will say, you know what, EECMS, I'm so sorry, it is now with the advocacy team and it's illegal. Now we will have to wait for a court date. So please ensure that you do that in time, should you undergo an investigation. Okay, so that's summary of the Employment Equity Act. A little bit of theory. Let's look at practice. Executive summary, 20-year review. Okay, so this was something that the previous Labour Minister, Mildred Oliphant, about a year and a half, more or less a year and a half ago, published. And she then said the following: the pace of transformation has been very slow. Relative to the demographics of the economically active population, there's marginal progress in relation to equitable representation of designated groups, in particular Africans, colours, and disabled, and especially in the middle and senior and top management levels. So what did they do? They, meaning the department, they took the CEE reports from 2001 to 2017 and they went through the statistics based on what was submitted 2 years ago. Just to give you an example, 27,511 companies submitted their reports. Okay, so the CEE is a conciliation for employment equity. They took the reports for the past 16, 17 years and then came up with the following: women in the public sector still underrepresented. So in other words, women on top management, the target is 45.3%. That's now for women. Public sector achieved in top management 32.6%. Private sector, women in top management achieved 21.6%. Bearing in mind that the target is 45.3%. Women in senior management, the same target, of course. And public sector achieved 39% and private sector 32.3%. Disabled, you remember I mentioned your target for disabled equals 2% of headcount. Public sector achieved 1% and private sector not even 1%. So during DG reviews, it became evident that number of employers that are non-compliant or in breach of the Act continue to unfairly benefit financially from state by accessing state contracts, despite the lack of commitment to transform. Therefore, she mentioned it became prudent to promulgate Section 53 of the Act for the first time ever. Well, for the first time since 1998 when the Act was gazetted. And what does that mean? Colleagues, Section 53, every employer that makes an offer to conclude an agreement with any organ of state for the furnishing of supplies or services to that organ of state, or for the hiring or for the letting of anything, must, in future, if you are a designated employer, comply with Chapter 2 and 3. If you are deemed non-designated, comply with Chapter 2. Okay, so what I'd like to mention on this, remember, colleagues, I promised you that we're going to discuss a couple of things based on the Draft Amendment Act. Attached to that offer, if you deal with an organ of state, a certificate must be given on that is conclusive evidence that the employer comply with the chapters of the Act, and a declaration by the employer that it complies with the relevant chapters of the Act, which when verified by the DG is conclusive evidence. This section will now be promulgated. Why? Because clearly after 20 years after the EE Act was promulgated, employers did not transform their workplaces given the slow pace of transformation. And then Minister Mildred then said, especially for the previously disadvantaged groups such as Black women and people with disabilities, it became evident that penalties for non-compliance that were increased. Okay, the penalties were increased 1 August 2014. It was increased and it did not yield positive results because most of the non-compliant employers still budget for penalties and are prepared, colleagues, to settle outside the court of law. Therefore, she said the stick and carrot approach will now be introduced. It will ensure that those that are prepared to implement the law and comply with the requirements of the Act should then reap the benefits of access to state contracts. I will elaborate on Section 53 just now. So let's talk about the amendment bill. Ladies and gents, colleagues, please bear in mind, this is an amendment bill. It's not gazetted as yet. It was closed for public comments already. But remember, we will now see a need to wait for the bill to be gazetted before we can say it's concrete or cast in stone. So what I'm telling you now here, remember, it's an employment equity bill. It's not published yet, but should it be published, and we think how it will be published more or less, we will talk about the proposed amendments. The amendments, the purpose of the amendments would be to allow the Minister of Labour, which is now the Minister of Employment and Labour, to establish sectoral numerical targets for the purpose of ensuring equitable representation of suitably qualified people, blacks, women, and people with disability, and to enhance the administration of the Act. I'm going to talk about the sectoral targets a little bit later as well. So let's look at the proposed amendments. On the definitions. Definition of designated employer is amended by repealing paragraph B, which classified employers with fewer than 50 employees and turnover thresholds. Bottom line, meaning the following. Should this bill be amended as is or gazetted as is, all companies employing less than 50 people will be deemed non-designated, irrelevant of your turnover. So if you operate in agri, your turnover is more than 6 million and you employ 49 people, you will be deemed non-designated. So the industry thresholds, we believe, will fall away, and it will only be, do you employ more than 50 people, yes or no? If so, yes, you will need to be, or you will then be deemed designated. If you employ less than 50, you will be deemed non-designated. Remember, this is not gazetted yet. Colleagues, please don't send me an email next week to say you are so glad you don't need to comply anymore because you employ 48 people, but your turnover is 500 million rand. Please, this is not gazetted yet. Then a definition of the National Minimum Wage Commission will be introduced, and a definition of sectors will be included. I'll get to those. Still on definitions. Definition of state is included to ensure the certainty concerning the application of Section 53. Okay, so what the post-amendment bill is trying to do here is to see that companies cannot create loopholes on whether it's now a state contract or not. Bottom line is the following. A state will be any national or provincial department as defined in the Public Finance Management Act. It will also include municipalities or municipal entities as defined in the Local Government Municipal Systems Act, a constitutional institution as defined in the PFMA, being Parliament or a provincial legislature, any entity listed in Schedule 2 and 3 of the Public Finance Management Act. That definition will be introduced. Voluntary compliance will fall away. Amendment of Section 8. Currently, it states that psychological testing and other similar assessments of an employee are prohibited unless, number one, it has been scientifically shown to be valid and reliable, so that remains. And number B, it can be applied fairly to all employees, that remains. And it is not biased against any employer or group, that remains. And then the proposed amendment bill adds the following: or has been certified by the Health Professions Council of South Africa, established by Section 2 of the Health Professions Act, etc., or any other body which may be authorized by law to certify those psychological tests. A new Section 15A will be inserted. Okay, colleagues, what we believe will happen is the following. Sectoral targets will be introduced. Currently, we are only talking about EAP targets, economically active population. We have your provincial EAP targets and you have your national EAP targets. So going forward, it seems as if companies will be able to use either provincial or either national. But should this bill be gazetted, the Minister of Employment and Labour will be able to identify economic sectors for purposes of the admin of the Act and establish numerical targets for those sectors. In other words, we think the sectoral targets will be introduced to say, you know what, construction companies will be benchmarked against construction companies, or transport companies will be benchmarked against other transport or within the transport industry and the transport targets. Okay. So for me, I believe that this can be a positive change pertaining to employment equity, because a lot of, if I just take our client base, a lot of our clients, depending on the industry they operate in, is a male dominant industry and or a female dominant industry. Let's talk about male dominant industry. Construction, transport. Let's talk about female dominant, nurses, hospitals, etc. Okay, so we believe that the department will then introduce these sectoral targets, which I personally think will be to the positive side and the benefit when you prepare your new plan going forward. The sectoral target set may differentiate between occupational levels, subsectors, regions, and other relevant factors. The Minister may publish regulations listing the criteria to be applied. Right, so we are all waiting in anticipation. Section 20 of the Act will be then amended. Remember, Section 20 is you will have to prepare and implement an employment equity plan on how to achieve reasonable transformation in your company. Should sectoral targets be introduced, I personally think and believe that your EAP analysis will expire with immediate effect or by a certain date given in the Gazette, and you will have to then change your EE plan. Because remember now, your EE plan will not only be based on EAP targets pertaining to underrepresented races and genders, but it will also need to be targeted as per the sectoral targets that the Minister will introduce. Section 21 will be amended. The Minister to prescribe by regulation the manner in which employers are required to submit reports. 27 will be amended. Transfer the functions of the Conditions Commission in respect of reporting. So to introduce the Minimum Wage Commission. Section 37. Permit the Minister to prescribe by regulation the manner of service of compliance orders on employers, resulting in the following, colleagues. Going forward, when an inspection is happening, they can either post it through a registered post, or they can email it, or they can hand deliver or whatsoever. Okay, and we will again going forward see how that will change. Section 42 is amended to clarify that designated employers' compliance with your obligations to implement affirmative action may be measured against the demographic profile. Bottom line is, it seems that going forward, you will be able to use either national or regional. What we have seen in the past couple of months, if not years, is that some inspectors ask you to focus your plan on national targets. Other inspectors might request the regional targets for your province. And then you have another inspector that would say, I want to see both national and provincial. Going forward, it seems as if you will be able to use either or, as well as the sectoral target. Section 53, provided that state contracts may only be issued to employers that have been certified as being in compliance with obligations under the EE Act. Let's talk about that. Section 53. In other words, all the companies attending here today, if you have government or state-owned entities or enterprise, whatsoever the case may be, as a client, please take note of the following. Subsection 1 is amended to require that an employer attaches a certificate when you conclude a contract with state. In other words, evidence that you comply with the relevant chapters 2 and 3 of the Act. A new section is inserted to clarify the Minister of Labour may only issue, remember, may only issue a certificate to an employer if that employer, number 1, has achieved the applicable sectoral targets or has raised reasonable grounds for non-compliance. Number 2, you will only be issued that certificate if, number 2, you have submitted your EI2 and EI4 reports to the Department of Employment and Labour. And number 3, if your company has not been found within the previous 12 months to have breached the prohibition on unfair discrimination or to have paid wages below the level of the national minimum wage. Ladies and gents, colleagues, if Section 53 is to be introduced going forward, please get your house in order. Start to prepare so long. Okay, if your client is government or state-owned or whatsoever the case may, SOEs, etc., start to prepare now to see that should the sectoral targets be inserted and gazetted, that you know more or less what the way forward could and or would be. Amendment of Section 64A, which allowed for the setting of annual turnover thresholds. As mentioned, thresholds as per Schedule 4 will be repealed. If you employ less than 50 people, you are deemed non-designated, and that's that. Additional forms, EI15, 16AB, and EI17, EI15, request for an EE compliance certificate. You deal with government. 16AE compliance certificate for designated employers, and then there will be a B certificate for non-designated employers. Okay, so for companies going forward, when you do your BEE registration and or validation, or you get verified, sure the BEE verification agencies then usually require the acknowledgement of successful completion and submission of your reports. Going forward, there will be a Section 16B, because what happens now, if you employ less than 50 people, you are deemed non-designated. So the question we at EECMS had is, what will the verification agencies do in this regard? And we believe, we don't know for a fact as yet, but we believe with the verification agencies we had discussions with, that they will accept the EI16B because you are deemed non-designated. And then we believe that the verification agencies will then work on your payroll that they receive, and of course your organogram. That being said, please remember, if you need any BE advice, we have various business associates we can assist with that as well. EI17, economic sectors and subsectors. I'll get to that. Ladies and gents, colleagues, extremely important. When we talk about the EI4, that is the document that you will be submitting if you are deemed designated to the Department of Employment and Labour. This is not part of the proposed amendment bill anymore. This has been gazetted last year, the 8th of August. You, and I believe majority of clients attending here today, would have submitted the amended EI4 last year already. But let's go into it, because I personally believe that 90 to 95% of companies in South Africa did not do it 100% correct, and you will need to revisit to see what you are going to submit this year and or before 15th of January 2021. So let's look at that. Remember, this has been amended, it has been gazetted. The front cover of your EI4 remains the same. The only thing they have added there is that you now include the sub-industry that you operate in. In other words, some of the industries were amended, and then the sub-industries were introduced in the EI4, and then also whether you belong to a bargaining council or not has been introduced in the EI4. So when you submit this year, the EI4 and your EI2, but let's talk about the EI4, take the following into account. The objective is to collect information of remuneration gap between the highest paid and the lowest paid worker, and to assess inequalities in relation to races and genders in occupational levels. Colleagues, the remuneration gap between the one highest paid and the one lowest paid worker, we call that the vertical gap. Then the horizontal gap to assess inequalities in relation to race and genders in the occupational levels, being the following. Let's look at inequalities in middle management between races and genders, African, Indian, colored, and white males and females. Let's look at possible inequalities in junior management between African, Indian, colored, and white males and females. Okay, what is the end result that the Department of Employment and Labor wants to see here is whether there's possible discrimination pertaining to remuneration in the same occupational levels. Also take the following into account. Workforce profile in your EI2 must be taken into account for EI4. All employees have to be included. Fixed and variable remuneration in the EI4 must reflect exactly the same as the employees in your EI2. In the past, prior to 8th of August 2019, you had the possibility to say we employed 100 people and terminated 20, so we're going to provide the remuneration of 120 employees. That changed completely. If you employ on your EI2 under your workforce profile 100 employees, you will have to give the fixed and variable remuneration of that exact 100 employees in your EI4. Foreign nationals must also be included. Of course, no blank spaces. Let's talk about fixed and variable. Calculation of the remuneration must include 12 months. Okay, it must be in line with the period that your EI2 report covers. So let's assume the majority of companies in South Africa, the snapshot is 30th of September every year. So what does that mean? That means when we submit our remuneration, we have to work from 1 October 2019 to the 30th of September 2020 when we submit our report in October or November or December. Okay, so that remains the same as previous years. In case of employees who have not worked a full 12 months, you will need to extrapolate as if that person has been employed for the full 12 months pertaining to remuneration. So let's assume, again, we have an employee started 6 months prior to 30th of September this year. So what are we going to do? We're going to take the fixed and variable remuneration for 6 months. We're going to multiply it by 2. And that will be the fixed and variable that we will submit in our EI4. Remember, colleagues, why do they want it annualized? The answer is they want to compare apples with apples and pears with pears when you submit remuneration. Fixed and variable. Fixed or guaranteed remuneration include your salaries, your wages, your housing, accommodation subsidy, travel allowance, provision of a car, except of course where the car is being used to provide the employee to work, perform his or her duties. Any cash payments made to the employee, except if it's specifically excluded, I'll get to that. Any other payments in kind, as well as the employer's contribution to medical aid, pension, provident, income protection, funeral or death benefit schemes, similar benefit funds, etc., as well as your guaranteed annual bonus and or 13th check. That would all be deemed fixed remuneration. Variable remuneration will include the following: short-term incentives, annual or shorter incentives, generally cash performance-based payments, referrals, commission schemes, etc. Long-term incentives, longer than 1 year, usually share-based award schemes, cash-based settlement that has vesting period of more than 12 months. In other words, more than 1 year. Lump sums in respect of ongoing employment, in other words, back pay and leave paid upon termination. Discretionary payments not related to an employee's hours of work or performance. The taxable benefit portion of bursaries and scholarships. Ladies and gents, important here, provided to the employee or to the relative of that employee. So if your company gives a bursary or scholarship to a child of an employee, that will be deemed the variable remuneration of that employee. Dividends included as remuneration as fourth schedule of the Income Tax Act and overtime. Dividends, in other words, top management, usually directors of a company, should a dividend be declared, then that will form part and parcel of the variable remuneration of that top management individual. Excluded, specifically excluded. Any allowance, cash payment, or payment in kind provided to the employee to perform his or her duties, equipment, tools, provision of transport, etc. Gratuities, tips from customers, and gifts from the employer specifically excluded. Non-employment related lump sums such as severance pay. And then, of course, if there were no dividends declared, then of course the company take that amount to invest back into the company the following year. It will not be deemed the remuneration of the top management then. Changes to the EA4, effective 8th of August, please provide the remuneration of the employee with the highest total remuneration between fixed and variable for each occupational level, from top management to semi-skilled. Provide the remuneration of the one employee with the highest. Okay, I'm going to get to an example just now. Then, what you will need to submit towards the end of this year, please provide the remuneration of the employee with the lowest total remuneration between fixed and variable for the lowest occupational level. What we are saying here, which is unskilled, well, which is usually unskilled. Okay, so colleagues, what do you need to do? Let's assume you have top, senior, middle, junior management, and semi-skilled and unskilled employees. You'll need to give the fixed and variable remuneration of the one person in each level, race, and gender, the highest fixed and variable of your top manager, your senior manager, your middle manager, your junior manager, and your semi-skilled. And on the flip side, you will have to report the lowest total fixed and variable on your unskilled employee. Let's assume your company do not employ unskilled, but you have top, senior, middle, junior management, and semi-skilled. Then you will take the one employee in each occupational race and gender and level. In top management, you'll give the highest. Senior, you will give the highest. Middle, you will give the highest. Junior, you will give the highest. And semi-skilled, you will give the lowest. Okay, because that is in your case then the lowest occupational level. Let me use another practical example. If you have top management, senior, and middle management only, you will give the highest of top, the highest of senior, and the lowest of middle. Then you will also need to provide the average or the mean remuneration and the median and the remuneration. This will look quite familiar. This remained the same prior to 2019, the 8th of August, where you say your total number of employees, African males. In other words, you might have 3 African males, total remuneration 300,000 Rand. 1 colored male, total remuneration 60,000 Rand. And so I can go on to the bottom right. In our example, you will have your 100 employees with a total remuneration, fixed plus variable, of all 100 employees. That has been the same since 1998 to currently. Then please provide the remuneration of the employee with the highest total remuneration, fixed and variable, in terms of population group and gender for all occupational levels, except at the lowest occupational level. Okay, we said that. We are happy and satisfied with that. Then provide the remuneration of the employee, one employee, with the lowest total remuneration in your organization in terms of population group and gender, where a choice has to be made between 2 employees with the same total remuneration. Okay, so let's assume I am a white male in middle management. My fellow colleague, his name is Barry, he's also a white male in middle management. And let us assume that we employ from top management to unskilled employees, and Barry and I have the same total remuneration. In other words, I have 50,000 Rand fixed and 50,000 variable remuneration, but Barry has 80,000 Rand fixed and 20,000 Rand variable remuneration. Then we have to submit my remuneration because I have the higher variable remuneration. That you do for your top tiers, your top, senior, middle, junior, semi-skilled. When it comes to your unskilled and or your lowest occupational level, there, if you have the same total remuneration, you will need to submit the one person with the lower variable remuneration. On this slide, you will see there you have your African colored Indian white males and females and foreign nationals. Top management, you must give the one African male with the highest fixed and variable and total remuneration. Should you employ 10 African males in top management, quite a big burden, especially for your payroll and your HR managers. Please, you will need to go from highest to lowest on African males. You employ 10 African males top management, submit the one African male with the highest fixed and variable remuneration. And you do the same exercise for your colored Indian white, African colored Indian white females as well, and your foreign nationals. So you select the one person with the highest of on top management, as well as senior management, as well as middle management, as well as skilled technical and or junior management, as well as semi-skilled. And when it comes to your unskilled, if that is your lowest occupational level in your company, you must indicate the one African male with the lowest fixed and variable remuneration. So on your higher levels, the one race and gender in each occupational level of the higher levels submit to one person with the highest fixed and variable. But on your lowest occupational level in your company, which might even be middle management, you must there submit to one person with the lowest. Please note that the average or mean remuneration involves adding up a number of amounts in remuneration, dividing the total by total number of employees. The median is the middle value. So on this slide, what is the average annual remuneration of the top 10% of your top earners? Okay, so we're going to say it's an easy exercise in this case. We're going to have EECMS, we have 100 employees, and we're going to say from highest to lowest, and you're then going to take your top 10 people, because 10% of the 100 equals 10 people, and we're going to say what is the average remuneration of the top 10 people in our company. You calculate, you divide by 10, it gives you, of course, the average annual remuneration of the top 10%. Then you do the same for the bottom 10%. Now what I want to tell you, and you can maybe make a note of this, let's assume we have 112 employees. So the question is the average annual remuneration of the top 10% of your top earners. If we employ 112 people, it would mean that 10% of 112 people equals 11.2 people. So we will take the remuneration of person number 1 plus 2 plus 3, 4, 5, 6, 7, 8, 9, 10, as well as person number 11. We will then add 20% of the 12th person and divide it by 11.2, resulting in 10% of your top earners. If you employ 115 people, you will take the top 11 people plus 50% of the 12th person, divide by 11.5, will give you the average of the top 10% of 115. Okay, colleagues, you can see that can be an immense admin burden. Then, second question, what is the average annual remuneration for the bottom 10? So you do exactly the same exercise, but for the bottom 10%. What is the median earners? In other words, the middle person. Let's assume we employ 100 people. You will take the total remuneration of person number 50 plus person number 51. You will divide it by 2, and that will give the middle person's remuneration. Please indicate whether your organization has a policy in place to address and close the vertical gap between the highest and lowest paid employees. Colleagues, please, last year you might have said, no, you do not have a policy. Please, I know what the future will hold. Well, I believe I know what might happen in the future pertaining to this document. The Department of Employment and Labor, I believe, might red flag companies saying, no, you do not have a policy to address and close the vertical gap. Because why not? Because now the next question is, how many times is the vertical gap between the highest and lowest paid worker in your organization in terms of your policy? Let's assume the highest person earns 100,000 Rand per annum and the lowest person earns 10,000 Rand per annum. The vertical gap would be 10. Why? Because the one highest person earns 10 times more per annum than the one lowest earner. Is the remuneration gap between the highest and lowest paid employee in your organization aligned to your policy, yes or no? Please, if not, align it to your policy. Colleagues, get your policy in place. Please do not say no on any of these tiers, because I'm extremely afraid that the DoEL might red flag that in future. If you need a vertical gap policy, even if you did not have one for last year, or you might need one for this year going forward, please send me an email. I will provide you a quote. It's not a huge amount. My email address is cp@eecms.co.za, and we'll be able to assist. But please, when you submit your report towards the end of the year, do not say no that you don't have a policy. Rather get a policy in place. Then the question is, are your affirmative action measures to address the remuneration gap included in your plan? Please, again, don't say no, it's not included in our plan. If not, revisit your plan, relook your plan, and ensure that the AI measures to address the remuneration gap is included in there as well. Please indicate a key reason for the income differentials that apply in your organization. Prior to the 8th of August 2019, you were able to provide a couple of reasons. What we have seen as of past 8th of August last year is you can only now select one reason, one key reason. You will see when you submit your report, you most probably have seen it last year as well. When you select on qualifications, it will by default only accept qualifications. Or performance, it will only accept performance. I'll get to the questions on the EA4 because this is imperative that you understand how to compile and complete and submit this report. Okay, back then to the proposed changes, not gazetted yet, but you will see what the Department of Employment and Labour did. They went on and they said, you know what, they introduced quite a number of additional sectors, whereas you will be able to see here in the past, or currently, sorry, it is only agriculture. In future, should it be gazetted like the amendment bill, it will indicate agriculture, forestry, and fishing. And then the DoEL will also then introduce subsectors: crop and animal production, forestry and logging, fishing, aquaculture, etc. Then you have mining and quarrying, and you have subsectors. Manufacturing with subsectors. I did email this presentation to each of the attendees attending here today. You can go through it. You will see it's quite an exhaustive list that will be amended, or that we believe will be amended, pertaining to sectors, additional sectors that will be introduced, and subsectors and or divisions that will be introduced. There in front of you, you will see our contact details, company website address, www.eecms.co.za. My contact number is on there and it's on your slides, I believe, as well. So I've got a question here from Tandu. Tandu, the question is, if the composition does not reflect the occupational levels mentioned, does that become a non-compliance? Because you mentioned additions as per the designated groups such as black males, colored males, and females, white males, disabled males, etc., or persons, etc. Okay, it will definitely become a non-compliance issue, yes. So in other words, when you undergo a DG review, they will not say it's non-compliant. Okay, they will say due to the fact that it's partial, well, they will say it's partially compliant. But to answer you, Tando, it will not be an immediate referral to the Labour Court. The only reasoning or the recommendation would then be due to the fact that you did not adhere to all the occupational levels. It's a partial compliance or partial non-compliance. Please resuscitate your committee as per our DG recommendations and then redo your EAP analysis and your E-plan. Just, I don't know how many companies here underwent the DG review and or investigation the past couple of months and or years and or maybe currently. But what we have also seen is that 99% of all the cases that we have been involved in, they change the procedural investigation to a DG review. And in the DG review, they request the company to change your plan. Remember, colleagues, if your company has undergone or currently is undergoing a DG review, the recommendations there is not to change your plan, your current plan. It is to introduce a new EAP analysis and a new EE plan, starting from now to whenever. Please bear that in mind. We've seen it where companies then change the wording and whatsoever of the current plan that was rejected by the department. When they look at that and they provide recommendations, it's not we recommend you to change your old plan. It is we cancel your old plan, do a new one. Then I've got a question here from Karen. If the organization is registered nationally, what percentages should they comply with for the various levels of management? Karen, okay, what we have seen, should you operate nationally and or you have like us a national footprint, then you are able to use the national EAP targets. However, what we have seen, there's quite an inconsistency when it comes to certain investigations where one person would say, I want to see national targets, another would say, I want to see provincial targets, another would say, I want to see both national and provincial. When it comes to DG reviews, they require companies to have national and provincial. Okay, so Karen, my recommendation there would be you look at both, especially if you have a national footprint. Which document of the EEA is the employer required to display in the work environment? From Dlamini. Okay, the document required that it's about the EEA 3, and that is the summary of the Employment Equity Act, as well as the basic conditions of the Employment Equity Act. Those are the big posters that you place where all your employees can visit and revisit the wording. Now I've got a question from Cosmos. Is the E-manager counted as part of the committee constituency? If so, which group do they represent? Yes, they can be part of the constituency. They will represent senior management, because it must be a senior manager position in the company. And then Cosmos, that person then will, be, of course, be the critical link between what is being discussed in the committee and reporting back to top management. Yes, your E-manager can be the representative of senior management as well. I've got from Mervyn, what happens if you do not stick to your EE plan? Okay, what you will find, Mervyn, very, very good question. Thanks, Scott. What we've seen in practice, the majority of companies, and I personally believe that due to certain reasons, amongst others, the COVID-19 for 2020, I believe the majority of companies in South Africa will not achieve their plan. The goals and the targets that you might have set up in your plan 3 years ago, or 2 years ago, or last year, we never anticipated an epidemic that happened globally. So I personally believe majority of companies will not achieve goals and targets. Mervyn, what will you do? When you report on your EI2 towards the end of the year, you revisit your plan, you look at what you promised and or not promised, but what you anticipated. If you have not achieved that, then you have the ability or facility in the EI2 to say where they meaning now the EI2 report actually request, did you achieve your objectives for this year as set out in your EE plan? Mervyn, you're going to say, no, we did not achieve it, and then you're going to provide reasons due to the economic circumstances, due to COVID-19, due to retrenchment, due to whatsoever happened in your company. You're just going to say we did not achieve our goals due to the following. It's 100% accepted by the Department of Employment and Labour. Then I have a comment here. You will likely be to be fined if you do not stick to your plan. Look, what happens there, if currently you do not stick to your plan and you did not achieve your goals as per your current plan, it's not the end of the world as long as you have valid reasons for that. What we have seen, however, is when it comes to a DG review and you create a plan that's accepted by the Director General, because remember, it goes to the Chief Inspectorate after the inspector, and then it goes to the advocacy team, and then it goes to the Director General, and the Director General say, you know what, we accept your feedback on the recommendations, we now approve this plan. Ladies and gents, colleagues, believe you me, then stick to that plan. Because if it was a DG review plan and you do not adhere to your targets and goals without not having exceptionally good reasons, then that could be referred to the Labour Court, yes. Can an HR manager be part of the EE team? In 90% of the companies we assist with, your HR manager usually is your EE manager. That is most probably the best person to be your EE manager. It's the best person and or people. We have a client with 6 HR managers in their committee. Why? Because that HR manager needs to look at the EIP targets ongoing. Okay, so yes, HR manager definitely, preferably part of the team. I have a query here. The Department of Employment and Labour has always confused the assignment and appointment of the EE manager. Can you clarify on that? Okay, the appointment of E-manager must be a formal written document, formal appointment letter to be signed by the E-manager and CEO, and it must adhere to those 4 rules that I've mentioned. If you didn't pick up on those 4 rules, it will be placed onto YouTube by next week, Wednesday. Just please revisit these 4 rules, and once you adhere to that, believe you me, we successfully passed 62 DG reviews with that letter and those 4 rules. Then I have a question here with regards to designated groups being represented. You mentioned all the races with both males and females. What about foreign nationals? If the organization has a couple of foreign nationals, should they also not be represented, both males and females? Very, very valid question. As per the legislation and the regulations, there's no statistics available for foreign nationals. In the majority of DG reviews that we attended to, if the Department of Employment and Labour Inspector sees that there is a number of foreign nationals, they usually come up with something like cease all the employment of foreign nationals in future. Or should a foreign national leave the company, how will the company look at the underrepresented pertaining to race and genders? Foreign nationals, to answer your question directly, the statistic there is 0. In other words, I wouldn't say the requirement, but the feeling is to have as little as possible foreign nationals. I've got a question here. Do foreign nationals that are South African citizens fall under the designated employees? And if so, how are they categorized? An example is that one born in foreign country, but is now a South African citizen or permanent resident. Okay, ladies and gents, bottom line is the following. I know there's a number of rules. It's all about the employment after a certain date in 1994, 27th of April, 90, and or prior to, etc., etc. Bottom line is the following. Permanent resident does not necessarily qualify. Born in a foreign country, but now South African citizen does not really necessarily. What you will have to do, request the ID document of the employee. When you open the ID document or your card that you received more recently, it will stipulate South African citizen or it will stipulate non-South African citizen. How is the committee elected? From Tommy, usually through a formal nomination process. Okay, so you see there's 20 people in senior management, or let's say middle management. You give that out to the 20 people in middle management and say, you know what, guys, these are the names. Please nominate someone. By a count of votes, you will have the most nominated person being appointed as a EE representative representing middle managers. For companies less than 50 people, is this for permanent staff or for permanent and temp? It includes temporary staff as well, and or contractual. In other words, you look at your total workforce, including your temp. If you have 40 temps and 20 full-time employees, you will have to report 60 people being above the 50. For the international company that employs under 20 employees, how would this regulation affect them? Remember, this is only a South African legislation. In other words, how does it work? You look at where was the company, the registration number and the pay-as-you-earn number, and that would be deemed the South African registered company. If it's a multinational, we'll only look at submitting the reports of the South African registered company. I know that foreign nationals impacts our B scoring, even if there is no impact on the EE, especially if they are in management control positions. Believe you me, should an inspector do an investigation, it will have an impact. Then I have a statement or question here. The EI4 horizontal gap can be due to different work, jobs, experience, and not discriminatory. Certain jobs which are different to each other, etc. Yes, remember, that is why you need to input whether you have or the reason for, key reason for disparities in income. Because there is, as per the 1 August 2014 Gazette, there are reasons for disparities in income. One person could have been a supervisor for the past year, another person could have been a supervisor for the past 15 years. Due to length of work, most probably the person being in that position for 12 years would earn more than the person being there for 1 year, but it will be a valid and justifiable reason. Is there a checklist template that we could use to ensure that we are ready for an inspector visit? What I'm going to do, I just quickly want to show you something. Question is there a list that we can or someone can provide? Checklist template, Monica? No, but what I can show you, I'm going to share our website. If everyone can maybe just write down this website address, it is www.eecms.co.za. And what all the delegates can do then is when you click on EE audit, it will take you through certain prompts. Okay, it will ask you how many employees, just for the purpose of doing an EE audit. just please say you have more than 50 employees, okay? Because if you say between 1 and 49, our system will say, okay, no, you are non-designated. So please just say 50 or more. Just say your turnover is above the threshold. And then when you click on next, it will go through and it will ask you a couple of questions. You are looking at more or less 45 minutes in total. Then I will receive a total full on audit on your profile. And based on the email address that you inputted when you completed that document, I will email the audit report showing where you are compliant and non-compliant. Such an audit, anything between 10,000 and 12,000 Rand that you will pay for. We are not in the business of selling audits. That's why you can go on to our website and get it at no cost. What is an acceptable vertical gap? Okay, the Department of Employment and Labour mentioned in a workshop 10. Okay, however, of course, they want it as low as possible, but currently there's not in writing anything acceptable pertaining to the vertical gap. But it was verbally mentioned 10. Are companies required by law to publish the vertical gap? Only the vertical gap policy, but you don't need to publish the vertical gap you must, but not the figures in terms of the highest and lowest paid earners. In other words, not the entire EA4, but your vertical gap policy will indicate what the vertical gap is. How do we get a template of the remuneration gap policy? Monica, there is no template legislated. That's something that we can assist with. You would look at 990 Rand and it's once off, and we request certain information and we draft that vertical gap policy for you. Are inspectors looking for proof of barriers? Yes, definitely. Tanya, remember your EIP analysis will show your barriers. So, and in investigation, they will of course request your EI12, meaning your EIP analysis, and then the barriers will be stipulated on there. What I'm going to do, I want to share something to the team here. I promise you, I'm going to elaborate a little bit on the EIP analysis. Ladies and gents, you can believe me if I'm telling you that when it comes to investigations, the department are hammering companies on EIP, underrepresented race and genders, etc. So I'm going to show you something here. It's called the E-Master. So what we do, we as EECMS, we are consultants, and we hopefully in future will be able to become your consultant. Then we utilize this online portal. So we obtain certain information from you. We input it as part of the setup, and we then do a handover to you and your company. You get your password, you change your password, and then you start to utilize this system on a weekly, daily and or weekly basis. And I want to show you something here. This is just a demo company. When we do the setup, we input certain information of your company. You have the facility to say, I want to please print my EE representative explanation letter, your EA1, etc., etc. So the CO and E manager, we assist, we input that as part of setup. You can edit the CO, you can edit the E manager. If you say, you know what, my employment equity manager, you want the EE manager appointment letter, I don't know whether you can see that in front of you, but immediately the appointment letter of the EE manager draws through correctly 100% in compliance with the sections 24. Then you have your employees. Once we have done setup, we do the handover, and you are then able to say, okay, if I need to add an employee, you add an employee, or if I need to promote or terminate, or whatsoever the case may be, you can do that. If I want to search for an employee, I can search an employee. I can say details, I want to promote or terminate, or whatsoever the case could be there. But imperative, okay, of course, your committee, the constituency of your EE committee is done through this online portal and as part of your setup to be 100% in compliance with the Act. Remember, this online portal we are utilizing, the slogan there is total and full EE compliance. Should you not have the correct EE committee, through this system and through EECMS becoming your consultants, hopefully very soon, we will assist that you are 100% in compliance. So I just want to show you, you are talking about the various occupational levels, races, genders, and when you do your nomination and you click on whatsoever the committee member here, if I click on senior management, just as an example, Mike and Kuna, and I say assign, it will immediately assign that person as part of the committee. I'll say that this person accepts, and if I want to, I open the appointment letter, everything is there to be signed off by the committee. Workforce profiles, I'm going to talk another 4 or 5 minutes about this online system. There's the latest workforce profile, demo company, standing on 1312 employees. If you add someone on your employment equity profile or an employee is being added, recruited, whatsoever the case may be, immediately it changes here. And then, of course, through this online portal, you can, of course, go back and say, but listen, how many people did we employ the 10th of July, 2018? You can see it immediately changed. You can actually go back to, let's say, 2010, 10th of October, 2010. This company had 7 employees. Okay, it can go back from or up to the 1st of January, 1900. You can, of course, do the same for your disabled people, your recruitment, promotions, etc. What I want to show you, there's a lot of questions coming through on the EIP and the EIP targets and the EIP analysis. Let's look on demo company. You can see there at the top, there's your latest EIP targets. I mentioned African males, 42.8%. Then the system provides you to say, if there is one, well, in this case, there is one African male in top management, and you can see there's one African female in top management. So how does it work? 1 divided by 1 gives you a representation of African males of 50%. So we had to take the 43 minus the 50, and it gives you an overrepresentation. Because the action is 50, the target is 43. So African males, already overrepresented in top management. But you have to do the same for colored males. The target is 5.2. This demo company is on 0 because they don't employ any colored male in top. Therefore, it's a minus 5.2%. In other words, an underachieve. And then you have to prioritize. So colleagues, what I have to elaborate on, and it's again imperative that this demo company now wants to say, okay, guys, let's do our plan. And not even with our plan. Let's say we want to employ another director in XYZ company. By law, you have to look at your actual. And you have to determine the under and over and then prioritize. And in this case, can everyone see immediately your colored males equals priority 1? So should you not employ a colored male, but you go to priority 2, which is white male, or priority 3, which is colored female, questions could be raised as long as you have your evidence, corroborative evidence. So what I want to show you here, and this is the wonderful thing about this system. If we said colored males was priority 1, this is a what if calculator. It's not concrete in the system. It is to play around before you employ, before you terminate, before you promote, before you do your plan. If we say we might employ one colored male, colleagues, immediately it changes the priorities. Okay, and then back just to show you here, the EA12, I did mention, it must be in a specific format onto the Department of Employment and Labor's logo, etc. And then, of course, your plan must be there, your vertical gap, your EI2, your EI4, etc. Okay, what I wanted to show you here, ladies and gents, colleagues, is that we can become your consultants. We utilize the online portal. We work throughout the entire of South Africa. Through this portal and us becoming your consultants, we do everything for you. When it comes to the EI2, with the push of a button, You have your EA2 with a push of a button. You have your EA4. All those calculations already being done based on what you input. Your plan is drawn up out of there. You will never again have to go out to consultants and or with yourself in-house to say, you know what do I need to do? Please come out. What's your quote? We need to do a new EE plan. The system does it for you. If there's consultants involved in this meeting, please liaise with me, contact me. The system is open to consultants as well, according to a prescribed fee, but I will discuss it with you. If I'm then going to close off with just one last thing I want to show, and then I'm going to open so that I see there's still a couple of questions. And then what we're then going to do is we're going to open it so that each person can unmute and maybe ask a question from there. Okay, I just want to show you one last thing. If you can please write down this website. It's www.eemasterclass.co.za, and I'm going to show you what eMasterclass is about. Okay, you have that website address. Please go on to that website address. There's numerous courses that you can attend. You get a very nice certificate. You claim it as internal training for BE purposes. And then, of course, very good then for your employment equity profile as well. And then before I'm going to open for questions and answers, remember, please go onto YouTube, type our company name in EECMS, subscribe to our link, and whenever we load anything new on it, you will be notified. Okay, so I see that there was a couple of it yourself. Yes,
Pieter, from my side, thank you very much for an excellent presentation. I have learned a great deal today, and I understand the framework which previously confused me completely. So once again, from my part, you've done an excellent job today. I thank you. No questions further. Should I need to consult, I will give you a call directly.
Ben, thank you very much. I really do appreciate it. Thanks a lot for attending here as well.
You're welcome.
Thank you.
Hi, Pieter.
Yes, hello, Mvula.
Hi, good morning. Or is it afternoon? Good morning still.
Morning.
Pieter, is there an online course available for the training of committee members? You know, during COVID, we're not in a position to get to the different locations where we have committees.
Yes. Look, of course, yes, there is online training available. My best advice in this regard will be to visit that EEMasterclass.co.za, because yes, it does come with a fee. I mean, even if we facilitate training to committees, even if it's like this through Zoom, it also comes at a fee. But what's nice about eMasterclass, they can attend it, they can do it in their own time, before hours, in hours, or after hours. The company pay X amount, you claim it for informal training for BE, and the employee receive a certificate. So my recommendation there would be to visit that site and then maybe look at the fundamentals of the EE committee, okay? Because that would be online purpose and receiving a certificate in hand. That would be my best advice. I'm sure there's other companies in South Africa also giving those opportunities. We do training, but we basically went a little bit out of that training. That's why we utilize the eMasterclass. If you can please visit eMasterclass.co.za, all the relevant information will be on there. Does it answer your question?
Certainly, Pieter, thank you very much again.
Only a pleasure. Thanks for your time.
Hi, Peter.
Hello, Megan.
It's Megan here. So I can see there's quite a bit of questions, or was a bit of questions in the chat about the committee. So my main question was, we are less than 50 staff members, and of course with you, like you said, it has to be a senior, middle, skilled. How do we do it from that aspect? We literally about 45 staff members.
Okay.
Is it mandatory for the CEO also to be part of that committee?
Preferably the CEO not to sit in the committee. A reason being is that the committee might then feel threatened to say what they really want to say. Okay, however, you cannot tell a CEO not to be involved at all. Okay, I would say when it comes to the preparation of your plan and your analysis, yes, of course, top management must be involved. But I wouldn't say with each and every quarterly meeting. Well, you can have meetings quarterly or monthly. Monthly, a bit of an overkill. Quarterly. But Megan, basically, let me ask you this. Your company, do you employ senior managers?
We've got senior, well, we're definitely not going to employ, we've got senior managers already.
You have senior managers. So then you will have a senior manager. Do you employ middle managers?
No.
Okay, then you won't have any middle management in your committee. Do you employ junior managers?
Yes.
Then you will have at least one junior manager representing junior management. And I would assume you also have semi-skilled and unskilled employees. Semi-skilled will then represent semi, and unskilled will represent unskilled. But Megan, to answer your question directly, once you have then your one, let's say, senior manager, your one junior, your one semi, and your one unskilled, then you have 4 people in your committee. Then if you employ more than one, let's say, African male, then you will also have an African male in your committee. If you do not employ any Indian males, then you will not have an Indian male in your committee. But I do get where you come from, because I mean, your committee can easily be 10 to 12 to 13 people that you are now taking out of 45 people in terms of productivity. But ladies and gents, colleagues, you can make a note of this as well. They meaning now the Department of Employment and Labour inspectors, refer to it as a valid quorum. Okay, so what is a valid quorum? It is the jurisdiction of the CEO to decide what a valid quorum is, meaning what is the number of percentage that of your committee members that must be involved for it to be a valid meeting. When I had a discussion with the directorate at the Department of Employment and Labour, he told me, he said, Peter, the CEO must, of course, last year we sat with the newly appointed minister, Mr. Tulas Nkexi, and we had a roundtable breakfast with him. And even in that regard, the bottom line is when it comes to your valid quorum, it cannot be 10% or 20% or 30%. Okay, so our advice usually is you have a document stipulating that if more than 60% of your committee is involved, it will be deemed a valid quorum, meaning a valid committee meeting. So not all committee members have to attend all committee meetings. Does that maybe clarify something for you, Megan?
Yes, it does. So just, I think you maybe mentioned it before, but like you said, it would be from each occupational category, and it would be, how do you determine the race and the gender for each category? So if we just look at hypothetically junior, would it be one per race and gender, or just one person in my circumstance?
Okay, occupational categories fell away 1 August 2014. Okay, so it was written out of the Act, and it's now only occupational levels. Okay, so yes. to answer you directly, I think where the confusion comes into play, you don't need an African, Indian, colored, and white in junior management. You only need one junior manager.
Okay.
If you have 10 people in junior management, being let's say one African, Indian, colored, and white male, one African, Indian, colored female, and 2 foreign, one foreign male, 1 foreign female, then you have 10 people in junior management. Only one person out of that 10 needs to sit in on the meetings.
So it's regardless of whatever race or gender they are, at least one person within that specific occupational level needs to be in that committee.
And that person will represent junior managers. However, once you have done your management level or your occupational levels, Then you say we have our 3 or 4 people, they represent the levels. Then, not to be the same person, you have to have an additional any African male in the company, or any Indian male in the company, any white male, female, etc. And that person will represent not the occupational level, but the race and gender.
Okay, okay, that makes sense. Thank you so much. Appreciate it.
Megan, only a pleasure. And hopefully, I think a couple of other people also asked that question.
Hi, Peter. Maybe it's more of a comment than a question. And this is in terms of your consultation process on Section 16. One of the issues that I had with the Department of Labor was the fact that if you have a company where most of your employees, for example, are represented by labor, or most of your interests, let's say Africans, for example, and females and males are represented by labor, it actually sounds ridiculous to have an African male, or let's say, for example, a white male where most of the white males are in a particular union, then to have a white male representing that particular designated group. It just doesn't sound nice. It's actually ridiculous and it doesn't make sense, you know?
Yeah, you know it, and that being said, you know what we have seen in the past as well. You have unskilled employees that by law must sit in the meetings as well. The problem that we experience is, and I feel for especially the unskilled employees as well as even semi-skilled. You know, now you're sitting in a meeting where you need to give all of this information pertaining to EAP, the economically active population, and we're going to draft the EAP analysis. And out of that, it's going to constitute our plan. And, you know, it's things that certain level employees, irrelevant of the race and or gender, just cannot.
But also, Peter, yeah, sorry, just to also come in there. One of my challenges with this kind of approach is that, you know, your unskilled and semi-skilled would not necessarily have a structure wherein they sit as an interest group to say, we are reflecting on this particular issues, you know, and therefore you expect them to become and represented, whereas it's a different story with the labor movement, where we know, for example, that they are represented and issues can be raised there. So it's one of those ridiculous things that the department really needs to deal with and do away with, you know.
Yes, yeah, you know what, like I mentioned, out of a theoretical point of view, I mean, the legislation is the legislation, but out of the practical point of view, we've seen, and unfortunately, I mean, the majority of your unskilled and even semi-skilled people in terms of the committee, they just cannot be of highest value pertaining to employment equity and transformation. However, by law, we have to have those occupational level employees in the committee. And then, of course, you know, when we go through training sessions and assist our clients, we get them involved to see that they can assist or maybe give feedback wherever possible from their side. But yes, point taken and agreed.
Thank you.
Hi, Peter.
Hello.
Hi, this is Miriam. We've been having multiple restructurings at our company since last year, and lost a lot of our EE committee members, either due to retrenchments or them taking VSPs. We haven't had a chance to reconstitute our EE committees, and as such have not had our quarterly meetings this year. Will a restructuring be a valid excuse for the Department of Labor, or is there another way we can manage this?
Look, I doubt that there's usually any valid excuse for the Department of Employment and Labor. I mean, anything, if there's an excuse, even if you are not able to report, you have to formally apply and complete the EI-14, etc., etc. Okay, so when it comes to resuscitating your committee or re-establishing, I would rather than say, sorry, you said it's Miriam, I think. No.
That's right, yes.
Miriam, I would rather say get the Employment Equity Committee as soon as possible in place, because yes, if they do an investigation, touch wood, next week, Monday, they can say, okay, but listen, you do not have a committee because you do not have any consultation letters, agendas, meeting minutes, appointment letters of your committee representatives, etc., etc. and that could cause problems for you. So my assumption, my recommendation, sorry, is to get a committee for each of the companies up and running as soon as possible. What has not happened in the past, you cannot change now. But please, as of and from Monday onwards, try your best to get your committees in place.
Even though a lot of those committee members might leave again in the foreseeable future.
Yeah, because your constituency of your committee must be in place. So again, you ensure that your constituency is 100%, but you have a quorum of, let's say, 60%. So if your committee is 10 people big and you have 6 people in the quarterly meetings, look, remember it's an hour or an hour and a half meeting once per quarter. 4 meetings per year. You understand what I'm saying? So, and then you just ensure that it's usually a valid quorum.
All right. So no, that's fine. Thank you so much for your
Sorry,
feedback.
I know it's not the answer you wanted, but no, please.
Yeah, it's just it seems like it's a talk exercise now because we might not have the same quality that we previously had, and you know, new members might first have to receive training. So, but yeah, I hear what you're saying. There is no excuse for the Department of Labor, so we will have to find a way around it.
Yes, please do.
Great. Thanks so much.
Thanks a lot, Miriam.
Pieter, I just wanted to ask you, for companies that have closed and all the employees are working remotely due to the COVID pandemic, how is the Department of Labor inspectors going to conduct inspections?
Sharon, thanks a lot. Very, very valid question. Well, to answer you, the second part of your question is, I know for a fact the Department of Employment and Labour inspectors are currently conducting inspections. We are currently busy with 3 DG reviews. So I know for a fact that they are out and about. How they do operate, whether they go to the committee members, I've seen with 2 of the inspectors that we are liaising with currently, we're basically working through information technology, through emails, through Zoom meetings, through sending the meeting minutes to the relevant committee members, through committee members sitting in meetings like we are doing currently. So in other words, I don't know what they would do if they go about a company saying, you know what, sorry, we don't have any information technology and we are not working at the office or whatsoever the case may be. I don't know how they're going to look at that. However, Sharon, I also have to say, you know what, surely the Department of Employment and Labour inspectors would also be humane in terms of, you know what, we do understand for 3 or 4 months your company was working remotely, employees did not come in. I know of numerous companies that had to close down for a week because of COVID, that the COVID breakout, and then they need to sanitize everything first, etc. Okay, so what I've seen is that the inspectors are human as well. They do understand for valid reasons that you provide. I mean, surely 3 or 4 years from now, I'm sure we won't be able to provide the same reasons, but for now, they do understand, or that is the personal touch and feeling that we receive from the inspectors that we work with.
Okay, thank you very much, Pieter.
Only a pleasure.
Hi, Pieter, how's it?
Yes, good, and you?
I'm very well. Hi, everyone also who's listening. Pieter, I have a question here with regards to especially employment equity reps. So obviously, once a committee is formulated, they reps need to be selected, right?
Yes.
So in the case whereby obviously I saw you've shown those stats. So let's say a company is lacking somewhere, maybe they are underrepresented somewhere. The employment equity reps, can they maybe included in the recruitment process so that maybe they can facilitate, especially in terms of where the underrepresentation is, so that maybe they can work closely with the HR consultants so that they can maybe cover the gaps. Is that permissible? Is that permissible?
Sorry, I just don't understand the question. Is what permissible to employ?
Obviously, let's say a company is underrepresented in one of the categories.
Yes.
in the analysis.
Yes.
So employment reps, I mean employment equity reps, are they maybe supposed to play a part in terms of recruitment? Should they sit in the panel of recruitment as well?
Yes, yeah, they
Or
could
maybe
be.
that's the
Yeah,
they
no, no,
could be.
absolutely. Absolutely. Remember, I'm not saying make your E committee part and parcel of each and every possible position that's opening up. Again, it will depend from one company to the next. It's not legislated that they must be involved, but of course they also need to monitor the plan on an ongoing basis or on a quarterly basis. Either or, depending on your company. But again, um, the decision could come from top management saying, you know what, we're not going to invite the entire committee every time. You can imagine Marion Roberts having 60, 65 branches throughout South Africa. They're not going to call in the entire committee when they employ someone each and every time. But usually, your HR department will be your best department, if I may, to um, to basically facilitate that process, to look at the priorities. Does it answer your question there? I just see here, okay, I'm going to take one or two last questions. I'll just see from Samantha here. If you employ a person on a contractual basis more than 1 year, do you count the person as one or for each time they are employed during the reporting period? Okay, just to answer a question, if you employ someone for a fixed term of 1 year, it's deemed a full-time employee of your company. Okay, even if it's a temporary employee service contract more than 3 months, deemed full-time. I'm going to take two last questions. Samantha, okay, I see that you're still in. Hopefully it answered your question. If you employ a person for 1 year, you will have that person on for 1 year. It will be deemed a full-time employee because it's more than 3 months. What I would then say is if you extend the 1 year, otherwise just keep that person on. Otherwise you will need to terminate and employ. So now you have one African male you terminate and one African male you employ in the same level with the same duties. My assumption there would be that it will just be an extension of your fixed term contract. I'm going to allow for one last question, colleagues. I need to travel again. If it's okay, let's look at one last question. Of course, if you have any other questions after this, pop me an email. But let's see, is there anyone, one last question we can maybe attend to?
Yes, Pieter, my name is Ash. A question around the less than 50 employees. Aren't we opening ourselves up to an imbalance of employing people if the less than 50 employee regulation and a high total turnover is implemented? Because a lot of companies are specialists in their field, and they may skew the employment ratio. Aren't we opening ourselves up if we don't if they are excluded now from the
Absolutely. No,
from this process?
Ash, I agree 100% with you. My big thing is that if you look at red flags, because when I read through the initial draft amendment bill, I think July 2017, and I read that the turnover threshold as per Schedule 4 might fall away, my first question is, and it was, what are companies going to do? According to me, they're either going to retrench or they're going to split companies. What's companies going to do employing 53 or 54 people and they know if they employ 49, they don't need to be there, they are then deemed non-designated and they don't need to comply anymore. They're going to say, well, not well, but according to me, a lot of companies will say, you know what, 54 people, let's get rid of 5. Let's make them independent contractors. Let's make them start their own business. Let's retrench them. Let's split the company. Let's whatsoever to fall out of the ambience of the amendment bill should it be gazetted as is. So point taken, and yes, agreed with you. Ash, does that satisfy your question?
Yes, it does. It does. Thank you very much.
Or statement for that matter. I totally agree with you. Yes. I think it's going to be very, very skewed and yet to be seen in future what's going to happen in that regard.
Agree with you. Thank you.
Please, if you need any further questions or training sessions whatsoever, pop me an email. You have my email address. Should you need the utmost benefit of our services and the online portal we utilize, please pop me an email. You will never look back in terms of employment equity. So from our studios here at Pretoria, thank you very much for your time. I'm going to end the meeting and we will chat again soon. Thanks a lot, everyone.